We're on record in the matter of Vincenzi v. Reeves, D21 633 8810. This is time and date for hearing on the initial November 8, 2021 motion related to financials and expert fees, a limited opposition followed by a full opposition of January 24, 2021, and a reply dated January 28, 2022. May I have appearances starting with Ms. Gallagher?
Good morning, Your Honor. Denise Gallagher, bar number 5739. I represent the plaintiff, Kevin D. Vincenzi, who is present via Blue Jeans.
Very well. For defendant, Ms. Reeves?
Good morning, Your Honor. Sean Wilson, 14, and I represent the defendant respondent, Jennifer Reeves, who is present via Blue Jeans today.
I am not seeing her. I see Mr. Vincenzi, but not Ms. Reeves.
He has her thing blocked, it looks like.
Ma'am, I need you to open up your camera. Ms. Reeves? There we go. Ms. Reeves, can you turn on your camera?
Yeah, there we go.
You can mute yourself, but just turn your camera on. Perfect. All right. So
I'm sorry, Your Honor. I just wondered, what is the firefiles.ai note taker, Kevin?
that's Mr. Vincenzi.
Yeah, that's my virtual AI. It follows me to all my meetings, so it's something that I can't.
Oh, that's not another person. That's just a virtual.
It's a virtual machine. So any of my business meetings or what have you, it follows me into the room and then takes notation. That's it.
Got it. Thank you.
You're welcome.
All right. So, folks, we had a January 18, 2022 stipulation and order. We had some initial UCCJAs with Texas. I want to make sure that I have all of the pleadings that we need for this morning. I'll start with Ms. Gallagher as plaintiff. We have the November 8th initial motion, your limited reply, followed by a more fleshed out reply of January 24th, and then opposition, excuse me, followed by Ms. Reeves' January 28th reply, correct?
Yes, Your Honor.
Okay. Ms. Gallagher?
So.
Yes, all right. At the outset, I do want to thank Ms. Reeves' counsel in reviewing their argument related to the Frazier case. I would agree, I was wrong in terms of the status of when Frazier would apply. So I appreciate you guys briefing it and humoring me. It would appear that the NRS 125040 is the governing provision. I was able to locate one case. It's the Rouhani case. It's unpublished, though, that deals with preliminary award of preliminary expert fees, and it does specifically cite to NRS 125040 and refers for support to cases related to award for attorney's fees, but it does deal with preliminary expert fees.
Thank you, Your Honor. I won't
Belabor
argue. Yep.
Okay.
That's it. Good enough for me.
All right. Anything else you want to tell me? In the pleadings, I saw you were listing one expert. I saw on January 28th you filed the disclosure for Anthem Forensics, and you were requesting $20,000. Is that correct? Or I'm sorry, $10,000.
That's right.
A $10,000 retainer, and then $280 or $390 an hour, depending on who the party was.
That's correct, Your Honor. So the initial estimate obviously was filed by a prior counsel months ago, but with our reply, you will see that the retainer fee is $10,000, and then it's a monthly. They'll just get monthly bills thereafter based on the hourly rates. The court could either, I don't know how the court prefers to do it, with a lump sum award to say here it is, or to say, here's Anthem's billings on a monthly basis, and we submit that to the plaintiff for payment, subject to retaxing at the time of trial. I don't know how the court prefers to go about it. either way is fine for us, Judge. We just need the ability, obviously, to get the initial retainer, at least at a minimum, to get them started, and so that they can get paid for their work as it progresses.
Okay. Thank you, Mr. Goldstein. Ms. Gallagher?
Your Honor, I had an issue with the $20,000. I don't think $7,500 to $10,000 is unreasonable for a retainer for an expert. By way of my opposition, I just wanted the court to know that Kevin's CPA does keep impeccable records, so I don't believe that the job of this particular valuator is going to be as bad as it would be for somebody who doesn't keep good records or that type of thing. So I wouldn't have an issue with the retainer. I would have an issue with just sending bills to Mr. Vincenzi and expecting him to pay them. I don't believe that this case and the length of this domestic partnership warrants that Kevin should pay 100% of every single expense in the entire litigation from now until the end of time. He's already shelled out probably close to $50,000 in this case between attorney's fees, Kathleen Bergquist, child support, travel expenses. We have to start to put a cap on things because I'm starting to feel that this case is becoming a free-for-all when it comes to finances. And on a 3-year domestic partnership with a mom who has a college degree as a geologist and is capable of making over $100,000 a year, I don't think that it's fair, equitable that Mr. Vincenzi is just an open checkbook.
So
we need some guidance in that respect.
Ms. Gallagher, the stipulation and order related to interim financials was, you guys stipulated that it'd be valid through today's hearing. Are we going to retain some of those agreements? For example, we have a FaceTime agreement, we have a family support agreement, we have our family wizard agreement, we have some medical
agreements. We filed a motion yesterday, just to let you know. I mean, we filed a motion yesterday because there's been some issues that have arisen which we believe is creating there to be more expenses than necessary in this case. Okay. So you're going to hear that motion, I think, at the end of the first week of March. Okay. We do have Kathleen Bergquist on board, and so another issue that I have is that we're starting to litigate custodial issues in front of you. And what is the point then of my client having provided $14,000 to Ms. Bergquist if A, we're not going to let her do her job, and B, Ms. Reeves is going to wait 3-4 weeks before even engaging with her. So these things are raised in my motion, and you will hear that in a few weeks.
Okay. So can we then, I don't want to impact the stipulation and order that you have. Can we then agree that the terms of the stipulation and order related to the custody matters will continue until we hear the motions and Mr. Goldstein's had an opportunity to file an opposition?
Well, I'm assuming due process requires that, so, and I
just want to make sure that stipulated that they would only be valid through today. So you guys are on notice that we were going to deal with it.
Look, and I know that at one point you had indicated that maybe the periods of time with the parents could be a little longer than the 2 weeks. This is creating some issues. It's super expensive. I don't know if you want to hear that today. I'd be willing to talk about it. But it's in my motion.
No, my question is, you guys stipulated
right.
The temporary orders would be valid until today's hearing. Subsequently, a motion's been filed. So,
yes,
since you've stipulated, everybody's on notice, I'm not violating anybody's due process rights. Are we then in agreement to carry the terms of the stipulation until I can hear this interim motion that'll be fully briefed and et cetera, et cetera?
Yes, Your Honor. I acknowledge Ms. Gallagher's statement that due process requires it, and of course I remind her of her similar arguments to you, Judge, when we filed our supplement the day before the hearing, and how Ms. Gallagher was incensed about it and couldn't believe that it was going to be, and objected strenuously to bringing anything up, and as she spent the last 10 minutes telling you about what her motion is going to be about here. So I would appreciate the same courtesy and opportunity to file our responsive papers before they're addressed before this court.
Okay.
With
I think the
regard
only
to-
thing that I probably really do need to raise, though, and I have been really trying to work with Mr. Goldstein regarding some of the smaller issues. I would assume he's not going to say I haven't emailed. The issue that I think we didn't realize at the time that we entered into the stipulation is that when my client goes to pick up drop off the kids at the end of the visitation, he has to spend 2 days in Midland, Texas. And if he's truly the only party working right now, I haven't been able to get an answer as to whether or not that's true. It would seem to me that it would be fair to ask Ms. Reeves to do the travel if Mr. Vincenzi is going to pay for it. That's the biggest issue that we're facing right now, is that he is booking the travel, paying for the travel, and doing the travel to go back to Midland. And they're exchanging on like Tuesdays and Wednesdays, so every other week he has to miss 2 days of work to take these kids back to Midland, Texas. I have tried to resolve this issue with Mr. Goldstein. I didn't get a response to my last email. I have no choice but to file a motion, because they asked that my client be financially responsible for everything, but they want him to miss about 15 to 20% of his work schedule every other week to take these kids back to Texas.
And I
So-
do remember
I
having
would
some
ha- I
of these
would have-
discussions initially.
I would
Mr.
have-
Goldstein?
Sorry, Your Honor. This issue is not before you today. I want to make the record clear about that, because I understand that certainly when I attempted to raise issues that weren't before the court at the last hearing, Ms. Gallagher objected and the court acknowledged that they weren't and gave everybody an opportunity to be briefed and to be heard. So I'd like to note that objection this time.
All right.
Secondly, Your Honor, I would ask Ms. Gallagher to put on the record exactly how many times Dad has flown and traveled to Midland since this has started. Because I believe the answer is once, maybe twice. So, and my client is saying once. So the idea that he is traveling back and forth every 2 weeks and missing 20% of his work or any of that kind of stuff is simply false. The representations to you on the record are false about that. And you're not hearing an objection from either side about that, Judge. So, again, this issue is not something before you today. And it's disheartening when it is brought up like this on a surprise basis without having an opportunity to fully brief you, because then we would show you the evidence that says he's only traveled on that once or twice occasion. My client says once. So,
Mr. Goldstein, he has to do it next week, and that is what our order says. So
right.
absent
And he hasn't
changing
done it at all. You just represented to the contrary, and this issue should not be addressed today. The temporary order should remain in place, and then we have
However,
an
your
opportunity to be back in a
predecessor-
month. We have an opportunity to be back in a month, which will allow a full briefing to be done, which means if he has to travel, it'll only be one more time in that time period.
All right.
So
folks.
there's not a huge prejudice to him on that.
All right, folks.
Well-
I just want to be real clear, so everybody knows where I'm at. You guys filed the stipulation and order. You agreed that the interim visit financial orders and the Our Family Wizard and the FaceTime stuff would be valid through today. That anticipates the parties are in notice that some things related to that stip and order would be dealt with today. Ms. Gallagher has
Right.
indicated that there are issues with it. She's filed a motion. That's fine. Since there's a motion filed, however, it anticipates that Ms. Reeves has an opportunity to file her opposition and Ms. Gallagher files her reply. I'm going to order that the terms of the stipulation and order that the parties filed carry through until everything can be heard on a fully briefed basis. Some of the stuff that was brought up in Mr. Vincenzi's January 24th opposition had to do with some medical decision issues, some breastfeeding issues, some issues related to Our Family Wizard. So there hasn't been any response on that. One of the requests was for a 24-hour response requirement to any Our Family Wizard. I'm going to go ahead and order that. That benefits the children. You guys are in separate locations, and it is very important that communication be timely and that both of you are involved. I do need to at least let you guys know my position with respect to breastfeeding. Breastfeeding does not trump the parental relationship. So, that is not a basis to deny visitation, delay visitation, or to otherwise attempt to control the case. All right?
Understood.
With respect to the expert request for fees, Mr. Goldstein, did you have an opportunity to reply? We kind of got sidetracked.
I didn't know that a reply was necessary, Your Honor. Like I indicated to you, a $10,000 retainer up front is what we're asking for. We just want our expert to get paid as it goes and not to have to hold the bag for the remainder of the trial.
All right,
So-
very well. All right, so folks, let's go back over some of the interim stuff that we have. We have an order for a stipulation order for $10,000 in sergeant fees. We have an agreement that Mr. Vincenzi is going to pay all of the costs related to Kathleen Berquist's full custody evaluation. To wit, he shall pay all costs to include her Dr. Berquist's travel to Texas, to include psychological testing of both parties, and to determine where the children will reside and with whom. The parties agree to comply with her recommendation. In addition, we have an additional order for Mr. Vincenzi to pay $5,000 family support and to be responsible for the costs of travel to and from Texas. I do agree with Ms. Gallagher that Mr. Vincenzi is fully bearing the financial burdens related to the costs of the case. To that end, the request for expert fees is denied. If Ms. Reeves chooses to, she may obtain her own expert fees. As both counsel are aware, depending on the results of trial, there may be some retaxation at the end, depending on what evidence is received. I'm going to ask Ms. Gallagher to draft the order from today's hearing. You guys are scheduled for March 14th, 2022. We have preserved your trial dates. So I'll see you guys on March 14th. Ms. Gallagher, anything on your behalf?
No, Your Honor, thank you.
Mr. Goldstein, anything on your behalf?
Just, I don't understand. I would just ask the court for some findings under 125.040. Denial of expert fees.
Let's look at 125.040. 125.040 states, subsection 1, any suit for divorce, the court may, in its discretion, upon application by either party, notice the other party, require either party to pay monies necessary to assist the other party in accomplishing one or more of the following. A, to provide temporary maintenance. That's been done. Mr. Vincenzi is paying, at least through our next hearing, $5,000 per month family support. To provide temporary support for the parties. That's subsection B. He's already doing that under the family support provision. To C, to enable the other party to carry on or defend such a suit. We have a stipulation for $10,000 in sergeant fees. Let's see, subsection 2, the court may make any order affecting property of the parties or either of them which it may deem necessary or desirable to accomplish the purposes of this section. Such orders shall be made by the court only after taking into consideration the financial situations of the parties. Subsection 3 states the court may make orders pursuant to this section concurrently with orders pursuant to NRS 125C00455. With respect to subsection 2, which seems to be one of the more pertinent ones, or subsection C, we already have sergeant fees awarded. I have taken into account the financial disclosures, including Mr. Vincenzi's detailed financial disclosure form. This is a discretionary award. It's the court's discretion in looking at the financial suits. I've made a finding that it appears to me that Mr. Vincenzi is bearing the full force of the financial orders to date. That's my finding. I'm not precluding Ms. Reeves from obtaining an expert if she chooses to do so. And I have indicated that evidence at the end of trial may warrant retaxation, but we're at too preliminary a stage for that determination to be made. So my order is to deny it. And Ms. Gallagher will prepare the order. I'm going to ask you to please send that over to Mr. Goldstein so that he may review and countersign, okay?
I will, thank you, Your Honor.
Thank you, guys. I'll see you in March.
Thank you, Your Honor.